My name is Brian, and this is my partner Horace here. And today we're going to answer the question based on an assignment given to us. And firstly, we're going to talk about negligence. And the definition of negligence is the omission to do something which a reasonable man would do, or to do something that a reasonable and a prudent man would not do. Established in the case Blyth and Birmingham Motor Works, 1856. And a person or property may be damaged due to this negligence. And generally, negligence is satisfied by three criteria: duty of care, breach of duty, and causation. So in this age, the courts will usually apply the Caparo test to determine whether there's a duty of care between the defendant and the plaintiff. However, there are certain cases where duty of care will automatically established between the defendant and plaintiff without any investigation. And one of these examples include a situation between a doctor and his patient, as established in the case Pippin and Shepherd, 1822. So therefore, there's no need for us to prove a duty of care exists using the Caparo test here, as duty of care has already been automatically established between the two doctors and the patient.
So after establishing duty of care, the plaintiff then has to establish that defendant has breached duty of care. There are a few factors to be considered. In this case, it was whether Dr. Richard was liable in failing to warn Domio of the risk of the surgery. In Montgomery and Lanarkshire Health Court, a diabetic mother claimed that she had the right to know the potential risk she would have suffered during natural childbirth. The Supreme Court held that she had the right to be warned of the risk, which was 9 to 10%, and she had the right to decide for herself what risk she was prepared to take. The Bolam test was replaced by the Montgomery test, where the materiality of risk had to be assessed by a reasonable patient after being informed of all risk of any recommended and alternative treatment by their doctor. Doctors are obliged to ensure that the patient is aware of all the risks involved, which Dr. Richard had failed to do. He did not inform Domio of the 5% risk that during the surgery, the blood clot could move up to his lungs and risk death by pulmonary embolism, which was exactly what happened. Furthermore, in Spencer and Hillingdon Hospital NHS Trust, a more relevant case as it involves pulmonary embolism, no mention was made by the doctors to the plaintiff that he might risk contracting deep vein thrombosis or pulmonary embolism as a result of the proposed surgery to treat his hernia. When the patient developed symptoms of pulmonary embolism after the surgery, he did not return to the hospital as urgently as he would have if he was informed of the risk, and therefore suffered further injuries as a result. The Montgomery test was applied, and the doctors were held liable for the damages suffered for not informing the plaintiff of the risk. This further proved that Dr. Richard was negligent in terms of consent. Furthermore, Domio was lucid and aware of his surroundings, so he could have made an informed choice for himself.
All right. So moving on, another issue faced by Dr. Richard is whether he breached his duty in terms of examination and diagnosis after he rushed to operate on Domio without waiting for the lab results, and as a result, further injuries were suffered by Domio. So a member of a particular profession discharges their duty by conforming to the standards of a reasonably competent member of the same profession. Therefore, doctors do not conform to the normal rules of breach of duty that apply to us, but instead are judged based on the acceptable standards of their own peers. And this was introduced in the case Bolam and Friam Barnett Hospital Management Committee, 1957, which established the Bolam test. And the Bolam test established that the defendant would not be held liable if he acted in a manner which is also regarded as acceptable by a reputable group of doctors. The defendant would not be held negligent even if others in the same profession would have disagreed with his actions. However, there was a major flaw in the Bolam's test, as if there was only just one medical body that agreed with the defendant's actions, then the defendant would not be held liable, no matter how illogical the decision was. This meant that doctors were virtually invincible in courts, as they could set their own standards, and this can be too low at times. However, this problem was fixed in the case Bolito and City and Hackney Health Authority, 1997, where the House of Lords held that the decision made by the Bolam's test must be logical and that ultimately it was the court and not medical opinion that determined the standard of care in medical cases. So now it doesn't matter if a doctor had support from a reputable group of doctors or medical opinions, the court is no longer bound to free him from negligence anymore. So the Bolam test can be overruled if the judges felt that the decision was illogical. And also in this case, for our case, we can apply the Maynard and West Midlands Regional Authority 1957 case. Here, doctors operated on the claimant before the lab results were available due to the urgency of the injuries. However, there was a risk of damage to the claimant's vocal cords, and indeed they were damaged. So hence the claimant sued the hospital on the grounds that they were negligent for carrying out the operation before waiting for the lab results. So the House of Lords held that the doctors were not liable after applying the Bolam test, as they acted in a way that was approved by a responsible medical body. In this case, our case, although Dr. Richard did not wait for the lab results, he proceeded with the surgery due to the urgency of Domio's injuries. So he couldn't wait any longer, or else Domio's injuries would have worsened, which is exactly what happened in the Maynard case as well. So Dr. Richard is not liable for negligence here, even though a pulmonary embolism did happen. And also moving on to the next issue, now faced by the other doctor, Dr. Newton, and the issue concerning Dr. Newton is whether he breached his duty in terms of treatment and clinical judgment. After Domio suffered spinal injuries after being operated on by Dr. Newton. So the Bolam test applies here too, but there is no evidence that suggests that Dr. Newton departed from standard medical procedure. Instead, it seems quite obvious that he made a simple error of judgment during the surgery, and now there are plenty of evidence that supports the fact that error of judgment does not amount to negligence. So this was firstly introduced in the case Hatcher and Black, 1954. Here, Lord Denning clarified the law on negligence against doctors and hospitals by saying that when a person who is ill goes into hospital for treatment, there's always some risk involved, no matter what type of medical care is used. All surgical operations definitely involve risk, so it's impossible that no mistakes or accidents will happen. So it would be very unfair to say that doctors and hospitals are negligent just because of a misadventure or mishap performed by the doctor. In my opinion, Dr. Newton did try to the best of his medical abilities, but unfortunately, he made an error in judgment during the surgery. But doctors are still human after all, and they're not perfect, they're not robots. So, and Lord Denning also supported my claim here, as he mentioned in Hatcher and Black, that it was wrong to hold a doctor negligent when something goes wrong in the medical procedure, even if an error of judgment was made, as doctors should only be held negligent if they fall below the standards of a reasonable doctor. And in this case, our case, there was no evidence that suggested that Dr. Newton there's no evidence that suggested that Dr. Newton fell below the standards of a reasonable doctor. And furthermore, based on the journal article we quoted, The Criminalization of Fatal Medical Mistakes, 2003, Dr. Newton's actions can be classified under misjudgment and not negligence. And misjudgment does not amount to negligence, according to the article. The article also claimed that it's very hard to prove negligence in medical cases. And moving on, another case that supports our point is Whitehouse and Jordan, 1981. And here an error of judgment did occur, as a senior registrar had pulled too long and hard for 25 minutes when trying to deliver a baby through forceps, and as a result, the baby was wedged and suffered brain damage. And here the House of Lords applied the Bolam test and found the doctor not negligent, as the evidence showed that he had not departed from standard medical procedure. And furthermore, Lord Denning, in the Court of Appeal, he argued that if he had made a judgment in the Court of Appeal, which was later reversed in the House of Lords, would he be considered negligent as well? In this case, Dr. Newton most likely followed standard medical procedure during the surgery, but made an error, simple error on judgment when he was tightening the wire cords around Domio's spinal cord. And he cannot be held negligent, because if he was held negligent, then it will open the floodgates for all other cases that involve an error on judgment during the medical procedure, and doctors will be swamped with lawsuits for any form of mistake they made. Of course, as Lord Denning mentioned in Whitehouse and Jordan, some acts or omissions are so blatantly below proper medical standards that they have to be considered as negligence. But this didn't happen in either Whitehouse and Jordan or this case itself, as there was no evidence that suggested that Dr. Newton fell below proper medical standards. And finally, the last case we found that supports our opinion is Hassel and Hillingdon Hospitals NHS Foundation Trust 2018. And this case involves a spinal cord injury due to the surgeon's actions as well. So here the claimant had a decompression and disc replacement surgery, which was performed by a spinal surgeon. And unfortunately, the claimant suffered a spinal cord injury during the operation, which made her permanently disabled. So she sued the hospital for a couple of reasons, one of which that the surgery was performed negligently to the extent that she suffered permanent injuries. And the Bolam test was applied here, and it was held that the procedure used by the surgeon was acceptable to some medical opinions, and this particular claim failed. So in conclusion, to wrap up the breach of duty issues here, both doctors did not breach their duty in terms of examination and diagnosis and treatment and clinical judgment respectively, as they most likely followed standard medical procedures, which is approved by medical experts. Dr. Richard couldn't wait for the lab results any longer due to the severity of Domio's injuries, and Dr. Newton most likely made a simple error of judgment during the surgery, and he cannot be held negligent just for simply making an error on judgment. However, Dr. Richard did breach his duty in terms of consent, as he failed to inform Domio of the 5% risk of pulmonary embolism that might occur during the surgery, which defies the rule in the Montgomery test regarding the duty of doctors. Furthermore, Domio was lucid at the time, and he has even admitted himself that he would have reconsidered taking the operation if he was informed of the risk. Therefore, Dr. Richard is liable for breaching his duty, whereas Dr. Newton isn't.
So now, in order to claim for damages, the defendant's negligent act or omission had to actually cause the damage. Here, Domio has the burden to prove that the loss he suffered, the pulmonary embolism, was in fact caused by Dr. Richard after establishing breach of duty. The first element of causation is causation in fact, which is established by the but-for test. This test is to see whether the defendant's act or omission did cause the claimant's damage. The defendant would only be liable if the claimant would not have suffered damage but for his action or omission. It originated from Lord Denning's decision on Cork and Kirby McLean and first applied in Barnet and Chelsea Kensington Hospital Management Committee. Here, 3 night watchmen went on the casualty ward of the hospital at around 5 p.m. complaining of vomiting and stomach pains after drinking tea. The doctor on duty refused to treat them, and one of the men soon died from arsenic poisoning. The House of Lords held that the hospital was not liable for his death, even though there was a breach of duty, as evidence showed that the man would have died anyway, even if he had gotten treatment. The failure to treat was not the cause of his death, and in this case, for Dr. Richard, it was his failure to disclose the risk of his operation to Domio that caused Domio's injury. Otherwise, Domio may not have agreed to the operation as he was lucid and the pulmonary embolism might never occur. This is supported by Chester and Aspar, where causation had been established very easily, as the surgeon did not inform the plaintiffs of the 1 to 2% risk of nerve damage during her back surgery, and she argued that she would have considered other options if informed of the risk. If the surgeon informed her, then the damage may not have occurred exactly the same as this case. Therefore, Dr. Richard was liable for causation in fact. Now, the second element is causation in law, which is also known as the remoteness of damage. And according to Winfield, remoteness is needed as the defendant cannot be made responsible infinitely for all the consequences of his wrongful conduct. This used to be assessed by the direct consequences test established in Ruff, Polemys, and Furness, Withy and Co. but later replaced by the reasonably foreseeability test established in the Wagon Mount. Here, the Privy Council ruled that real polymies was no longer good law and that the defendant was only liable if the direct losses were reasonably foreseeable. The reasonable foreseeability test was promptly replaced by the direct consequences test. If a foreseeable damage occurs, then the defendant will be liable for the full extent of the damage, no matter whether the extent of damage was foreseeable. In this case, for Dr. Richard, it was reasonably foreseeable that the pulmonary embolism might never occur, as there was a 5% risk, as he did not inform Domio, who might have refused the operation. Chester and Asfar also supports this case, as it was reasonably foreseeable that the patient will suffer nerve damage due to the 1 to 2% risk, so causation was easily established. Therefore, Dr. Richard was also liable in causation in law. So in conclusion, Domio could sue Richard for negligence, as Dr. Richard had met the 3 elements of negligence, which was duty of care, breach of duty of care, and causation. Dr. Richard is liable for breaching Domio's consent only and not in terms of examination and diagnosis. However, Dr. Newton cannot be sued by Domio for negligence during the surgery itself, as there is no evidence that suggests that he had departed from standard medical procedure, and he cannot be held negligent for an error in judgment. Therefore, he did not breach his duty of care to Domio.
Okay, so moving on to the Malaysian position now. So we have to determining duty of care through the Malaysian law is also the same as in English law, in that there is an automatic duty of care between a doctor and his patient. Therefore, both Dr. Richard and Dr. Newton owe the duty of care towards Domio. So moving on to breach of duty in the Malaysian position, the Bolam principle has been well received by the Malaysian courts in determining a doctor's standard of care in medical negligence cases. The development of the Bolam principle in Malaysia can be seen in the case Chin Kiao and Government of Malaysia and Anor. The case is brought by the defendants of the deceased who had died from an anaphylactic shock as a result of the injection of propane penicillin. So the plaintiff's family alleged that the doctor was negligent in prescribing the injection without making any prior inquiry from the patient, which would have revealed that he was allergic to the drug used. So the court applied the Bolam's test and held the doctor liable, stating that he should have asked or attempted to discover whether the patient was sensitive to the drug or not. So moving on, other relevant cases explaining the development of the Bolam principle in Malaysia can be seen in the case Elizabeth Chu and Government of Malaysia and Anor. In this case, Raja Aslan Shah J stated that a professional will not be deemed negligent as long as he has taken the steps that would normally be taken by a body by others in the same position. However, a professional who takes on a different view from another professional in the same profession is not necessarily in the breach of his duty, provided that his opinion is in accordance with what is regarded as proper by a body with a similar skilled profession. So therefore, the anesthetist was not negligent, as he was competent to do the sigmoidoscopic examination, and he had exhibited competent care and skill on the particular occasion. This technique was approved by a responsible body of medical professionals since 1956. It did not matter that there was another body of medical opinion that disagreed with his actions. So the judicial decisions in this case was important, as it was reaffirmed in the case of Khao Nan Seng and Nagama and Ors. Here, the federal court held that the duty of a doctor to his or her patient is to adhere to the reasonable standard of care and expertise. If there were differences in opinions in terms of the type of plasters that may be used, the defendant may not be liable as long as he or she opted for a treatment that was generally accepted within the profession itself. The Bolam's test was applied here, and the defendant was held liable, as all doctors were aware of the fact that blood circulation would be affected if the plaster was applied. And another example where there's a clear breach of standard of care can be seen in the case Chelia Manikam and the Government of Malaysia. In this case, the doctor had mistakenly diagnosed the child with perforated appendicitis when he was actually suffering from acute hemorrhagic pancreatitis. The child had died as a result of the wrong treatment, and the court held that the blunder was squarely on the defendant as he had failed to meet the standard medical competencies. And in Malaysia, being aware of the challenges to the Bolen principle, there are certain occasions that have departed from the Bolen principle, and the first case to depart from the Bolen principle and use the Rogers and Whittaker test can be seen in the case Kamalam A/P, Ragman and Ors, and Eastern Plantation Agency. And in the Australian case of Rogers and Whittaker, the plaintiff became almost completely blind in her left eye after a surgery was performed. And the surgery was not conducted negligently, but the plaintiff's allegation was based on the fact that the defendant had failed to warn her of the risk arising from the surgery. The doctor was held liable, and it was stated that a doctor has to warn his or her patient of a material risk which was involved in the treatment. A risk was material if he or she is likely to attach significance to it, or the medical practitioner is or should be reasonably aware that the particular patient, if warned of the risk, will be likely to attach significance to it. So back to the case of Kamalam, A.P. Ragman and Ors, and Eastern Plantation Agency. Mr. D was employed by the first defendant at the time of his death. Yet he had been suffering from hypertension, and he complained of feeling giddy and soon fainted and was brought to the estate clinic. He was prescribed and discharged soon after, and a few days later, a second defendant attended to him in the same clinic. A day later, as a result of his giddiness, he was taken to a hospital for emergency treatment and unfortunately passed away soon after. The court held that both defendants were held liable for their failure to provide an efficient ambulance service at the material time and for failure to admit Mr. D into the hospital earlier. The case showed that Whittaker's test not only applies to the disclosure of risk, but also to examination, treatment, and diagnosis as well. Besides that, moving on, the full reception of the Whittaker test can be seen in Fu Fiona and Dr. Su Folkman. In this case, the plaintiff got into a car accident which dislocated her vertebrae and sent her to the hospital. The defendant surgeon performed 2 surgeries, and the plaintiff became paralyzed from the first surgery, which led to the second surgery being performed. The plaintiff claimed that the defendant had failed to warn her of the risk of paralysis resulting from the first surgery and instead informed her that it was a minor procedure, which she consented to. She stated that she would not have readily agreed to the first procedure if she was warned of the risk in the first place. The federal court held that the Bolen's test should not be applied in cases involving disclosure of information, as the Whittaker's test was more appropriate. It was believed that professional opinion serves as a guidance to courts as to what constitutes as acceptable professional practice, but its reasonableness may be questioned by the courts. And also, moving on, there was confusion as to whether the test in Whittaker only applies to areas regarding consent or to examination, treatment, and diagnosis as well, as seen in the case Kamalam's case, and the confusion arose because Siti Norma Yaakob FCJ, in the case of Fu Fiona, went on to discuss about the case of Nasakis and Western General Hospital, which overruled the use of Bolen's tests for not only advice but also for diagnosis and treatment in Australia. Following the case of Fu Fiona, the decision in Rogers and Whittaker was applied in numerous Malaysian medical cases. An example of this can be seen in the Malaysian case Dominic Pu To Cheri and Ors and Dr. Gun Siu Fong in Arnor. Here, the plaintiffs were the personal representatives of the deceased. The deceased was found in the drain and was taken to the hospital. Less than 3 hours after arriving at the casualty department, he died. The plaintiffs commenced proceeding against the defendants, claiming that they failed to diagnose and treat his spinal injury. The federal court dismissed the appeal and stated that the standard of care that a medical practitioner should exercise is now is now a question which is for the ultimate consideration of the courts and no longer one for the medical profession alone to decide through a responsible body of medical opinion. So the Rogers and Whittaker test was applied, and in relation to the claim of mixed diagnosis and wrongful treatment. And
Oh, another case can be seen in Hassan bin Latullah in Kerajaan Malaysia. Here, the plaintiff was paralyzed after 2 surgical procedures performed by the defendant. He sued the defendant, claiming that he was negligent in performing the procedures. The High Court dismissed the claim, stating that the plaintiff had failed to show causative link between the resultant injury and the act of the defendant, and that the defendant had exercised the requisite degree of skill and care required of him by law. The plaintiff then appealed to the Court of Appeal, and one of the claims was that the judge had misdirected herself in adopting the Bolam test in determining whether the defendant had breached his duty of care towards the plaintiff. The court held that although the judge had made reference to the Bolam's test, perusal of the judgment showed that she had not based her opinion solely on the professional opinion and practice as envisaged by the Bolam principle. She had properly assessed and weighed all the evidence before her, particularly the opinion of the expert witnesses on the probable cause of the plaintiff's paralysis, before arriving at her own decision. The Bolam test was wholly rejected for all aspects of medical negligence in this case. The later case of Zul Hasnima binti Hassan Basri and another, and Dr. Kupu Velumani P and 2 Ors had clarified this issue. In this case, the cesarean section was delayed and Zul Hasnima had suffered uterine rupture as a result. She claimed that Dr. Kupu should have foreseen that Zul Hasnima might suffer a uterine rupture if CS was delayed, as she knew she had a condition called cephalopelvic disproportion after delivering her first baby. Her baby had cerebral injury as a result of the doctors failing to adequately resuscitate her. The court held that Dr. Kupu and the nursing staff were negligent in failing to properly diagnose her when she was in labor. The federal court stated that in deciding on whether there was negligence, and as the issues raised were relating to diagnosis and treatment, the applicable test would be the Bolam test, together with the Bolito addendum. As a result of this case, the Bolam's test will now be used when determining the doctor's standard of care in medical aspects of treatment and diagnosis, while the Whittaker test will be used when it comes to disclosure and giving advice to patients of the material risk of the treatment proposed. So much like when the England law was applied, Dr. Richard had a duty to advise Domio of the 5% risk that the blood clot could move up to his lungs and risk death by pulmonary embolism from the surgery. Domio is likely to attach great significance to it and may not have agreed to having the surgery performed if he was properly warned of the risk. Also, Domio was aware of his surroundings and is capable of making a decision. Therefore, Dr. Richard has breached duty of care. Now, as for Dr. Newton, the surgery that was performed by him, in which he had to tighten the C5, C6, and C7, is likely to be a common medical procedure in situations involving a spinal surgery. Since Dr. Newton had not departed from standard medical practice, he has not breached duty of care. In establishing causation, the but-for test was also used in Malaysia in the case of Swami and Matthews and Anor. In this case, the plaintiff claimed damages for negligence on the part of the first defendant, a medical officer employed by the second defendant, in treating his hands for an itch, for treating the plaintiff for an itch on his hands by injecting an arsenic preparation, acetyl arsen, which has alleged to have resulted in paralysis of his hands and legs. The medical evidence showed that it was not certain that the injection caused the paralysis. Therefore, the defendant was not liable. In this scenario, Domio would not have suffered from pulmonary embolism if Dr. Richard had not performed the surgery. So in applying the but-for test, Dr. Richard is likely to be liable. The reasonable foreseeability test was also approved in Malaysia in the case of Government of Malaysia and Jumat bin Mahmud and Ors. In this case, a pupil pricked the plaintiff's thigh with a pin which produced a shock, causing the latter to turn around, and his eye came into contact with the sharp end of the pencil that the pupil was holding. The eye had to be removed subsequently, and the court had to consider whether the risk of the injury to the plaintiff was foreseeable. The court held that the risk of the injury was not foreseeable, and constant vigilance in the classroom would not have prevented such harm from occurring. Another Malaysian case which applied the reasonable foreseeability test can be seen in Jaswat Singh and Central Electricity Board and Anor. Here, the plaintiff sued the defendants for damages arising out of the death of 5 buffaloes and 1 dog belonging to him as a result of their being electrocuted by coming into contact with a telephone wire belonging to the second defendants. The wire had been snapped on and was lying on the ground and resting on top of the aerial electricity lines belonging to the first defendants. It remained so resting till the day of the death of the buffaloes. The claim was based on the negligence of the servants of both defendants, or alternatively, the negligence of the servants of one or other of the defendants. It was found that the danger of the telephone wire becoming live and the death or injury to any person or animal was reasonably foreseeable. Therefore, the defendants were held liable, and applying the facts to the case, it was reasonably foreseeable that the surgery would cause pulmonary embolism, as the risk has been shown to be 5%. So, in conclusion, similar to when England law was applied, Domino could make a claim towards Dr. Richard as he was negligent, but could not make the claim to Dr. Newton as he did not breach duty of care. Thank you.
Thank you. Thanks for listening.